Okay, welcome everyone. Let's give 30 seconds for the rest of the attendee to join us online. Okay, I think while we wait for the rest of them to join us online, I'll probably just give an introduction about APACMed. First of all, welcome to the webinar, the Founder Series webinar. This is the fifth sessions that we are organizing since we launched the Founder Series, program three months ago. Yeah, and we've had a couple of webinars around M&A, corporate innovation, human-centered design, and clinical trials. So thank you for joining us for the session on IP today. So a little bit about APACMed. APACMed is a not-for-profit medical technology association. And what we do is that we lead efforts in advancing medical technology in order to raise standards of care for patients. Yeah, this will give you an idea of the members that are part of our association. I just want to highlight two categories of membership. If you look on the left side, you see some of the global companies that are represented here. And again, if we look at the top 30 global MedTech companies worldwide, 20 of them are members of APACMed, of course, including the likes of Johnson & Johnson, Medtronic, Abbott, Stryker, for example. But for purpose of today's webinar, we are focusing more on the founders and startup. I just want to draw your attention to the middle section. And this is where, our startups and our SMEs are featured. If we look at our member base of about 160 right now, 40% of them are startups. Startups across the traditional medical device space, the diagnostics, and the digital health space. And because we have a growing number of startups, we have developed a program called the Founder Series to support our startups in scaling up. Yeah, so broadly, there are three components. One is that the Founders Campus, where, like today, we look at specific issues that are relevant to the startups, and we onboard senior business leaders and industry advisors, to share their insights, on what it takes to address, certain issues. It could be regulations, it could be reimbursement, or it could be intellectual property, as in today's discussion. Secondly, we also want to look at how we can, bridge startups with corporates. And what we've done is that we have partnered with US-based MedTech innovator to run a competition and accelerator program, and in the process allow the startups to be able to engage with the global companies. And last but not least, we have also a Founders Circus program where we have a group of mentors who are very, very passionate about helping startups, and they have volunteered their time to support startups if they have questions or issues that needs to be addressed, and when they can support them. Yep. So today I'm very delighted to have on board Ren Jun to take us through today's webinar. So a little bit of an introduction about Ren Jun. Ren Jun is a principal with Baker McKenzie Wong Leow, and he leads its healthcare industry group. He represents local and international clients in intellectual property matters, advising on a full range of issues relating to the healthcare industry. And this includes regulatory compliance in respects of drugs and medical devices, clinical trials, product liability, recall issues, data exclusivity, patent linkage, competition, and anti-corruption issues. Ren Jun also sits on the Law Society of Singapore IP Committee and on the Executive Committee of the Association of Information Security Professionals. He is also a member of the Vaccines Working Group, the Singapore Association of Pharmaceutical Industry, a member of the International Trademark Association, as well as a member of the Regulatory Affairs Professional Association. So today's topic is on IP, and I think there are two reasons why we chose this topic, and we think it's very relevant to the founders and startups. The two reasons are, one, IP has always been paramount to any innovative medtech company's success in terms of protecting a company's core technology. And secondly, which I think is very important, is that medtech companies are increasingly, packaging sensors, softwares, and other digital features into their devices. And how is going digital shifting the way device companies protect their IP? And in addition to this too, medtech companies are also currently affected and challenged by, I feel, three concurrent technology-driven shifts. One is increasing pace of digitalization. Two, the shift to value-based healthcare. And three, new foundations of digital technology. Hence, we are really delighted to have Ren Jun here with us today to help us understand the impact of this development on IP and medtech innovation. Over to you, Ren Jun.
Okay, very good afternoon to everybody. Thanks so much, Gabriel, for your kind introduction. And again, thanks so much for extending this opportunity to me to present today on IP. I won't introduce myself any further, being mindful of time, but just to give you a little bit of context and background to what I do. Well, I'm a lawyer, and today's challenge for the presentation is to try to keep this as layman as possible, because I don't think that any of you, or in fact just a few of you, are legally trained. And I started out as an IP lawyer. I still am an IP lawyer. I have a very keen interest in the healthcare space, especially increasingly nowadays in the space of health tech. Okay. So this is today's agenda. I will touch on three main things. First, I will try to give you guys a very quick and dirty introduction to intellectual property and what it means to really conduct due diligence, meaning to unravel the extent of intellectual property that your company may potentially have. And then secondly, I will identify some common pitfalls that companies in your space they typically face or they make in relation to intellectual property. And third, how to ensure that you guys have a strong IP portfolio. I will try to keep this as interactive as possible. If you guys have any questions, please feel free to raise them via the chat function. Okay, on this slide, you will see 6 different boxes. And I'm trying to do in 5 minutes what 12 years in my career and 4 years in law school, I'm still trying to learn and grapple with intellectual property rights. So what really is intellectual property? And I think for a company, when you come into business and you ask yourself, what exactly is IP? You look at it as IP being this whole field of legal rights, and there are different buckets to intellectual property. Okay, some people may just think that IP is trade secrets or trademarks, but there are quite a few other types of intellectual property. And at this juncture, I just want to say that it is important that you try to understand that intellectual property rights encompass different types of rights, because if you get the foundation correct, it means that potentially your company can have more than one intellectual property right. And if you extrapolate that, it actually means that you have more than one type of way where you can actually commercialize your assets. Okay, so you see the 6 buckets, and the typical ones are trademarks, copyright, okay, designs, trade secrets, confidential information, and patents. And very quickly, each of them, they protect different types of things or rights. So for patents, they go towards inventions, okay? So if you are in the MedTech space and you have thought of an idea, or you have come up with a software and no one else has come up with that software before, and you want to apply for protection so that you can have a monopoly, okay? This is what patents can give to you. What IP rights typically give to business is a competitive advantage, because if you read the papers, you will actually think about, or you see some commentators, they say, okay, if you have IP, you probably have a monopoly, and to a certain extent, that can be true. Another point to note is that intellectual property rights are territorial in nature. So by territorial in nature, what it means is that if you have, let's say, a trademark that you register in Singapore, that does not mean that you have automatic protection in the rest of the world. So each and every single country, they treat that particular right quite differently. If you need to register a particular right, registering in one country may not give you protection, okay, in other countries. So what I'm going to do now is to talk a bit more about the different rights. I talked briefly about patents, and what patents are typically is they protect inventions, and these are some of the requirements to patents. The 3 main things are: it needs to be novel, which is new, it needs to have inventive step, and it needs to be capable of industrial application. So by novelty, what it means is that your invention cannot be disclosed before, or somebody else cannot have something similar before, such that if anything is out in the public domain, you look at it, okay, if it is reasonable for you to come up with something perhaps better, then I think your novelty is going to be destroyed already, or at the very least, your invention may not possess inventive step. Industrial application shouldn't be a problem for people in your business, because what it actually means is that is your invention capable of being applied to any type of industry. For patents, the protection can be up to 20 years, okay? And the last point on international patent applications, what it means is that there are certain regimes in place where to facilitate filing of your patents, you go to one country, you file for the patent, and you designate different countries in that single application. Okay, but ultimately, what this means is that, let's say you go to Singapore, your Singapore application, the Singapore Intellectual Property Office will channel your application to those designated countries that you have ticked in your application form. Okay. Moving on to confidential information and trade secrets. What this means is, okay, the difference between confidential information and trade secrets is, okay, on the one hand, you have patents, right? And patents, they protect inventions. Confidential information and trade secrets also kind of protect inventions and also broadly information. The difference is that you don't have to apply for registration when it comes to confidential information. So one very good example is the Coca-Cola formula, okay? For the longest time, Coke has protected its recipe, I think, for more than at least 70 or 80 years. And the only reason why they are able to do so is that they were able to keep secret this recipe. So the protection arises when the information can be considered to be confidential, and it was imparted in circumstances that imports an obligation of confidence. Okay, so how you usually do it is, let's say if you have created something which is quite secret in your company, and you want to protect it, but you want to save money and you don't want to apply for a patent. So you have employees or you have contractors, and these people, they are supposed to keep your information secret. You do so by non-disclosure agreements. You can contractually put in clauses in your contracts to say that, okay, all these things are confidential and you need to take steps to protect the information so that you don't disclose it out to the world. Because as you can see on the slides, once you disclose the information, your protection will be lost. Okay. I just want to pause here because I can't really see the chat questions when I share my screen. So Gabriel, if you can see any questions from the chat, maybe you can raise them.
Yep. Okay, sure. We'll do. At the moment, there are no questions yet. So if you have any questions, please feel free to drop your questions on the chat feature at the bottom of the Zoom platform. And then I will bring up the questions along the way.
Okay. Another type of IP rights that are quite typical in your business is a trademark. So trademarks can be your brands, right? It can be a logo, it can be your company name, and it can be your word. This one you need to register. Very simple to register. And trademarks, they cover different goods and services. So key points to note is, okay, you need to make sure that your logo or your brand name is not descriptive. So I give you an example. If let's say you want to register Apple for a fruit shop, then clearly the name of your fruit shop is descriptive. You cannot apply for registration. But on the other hand, if you have Apple for phones, right, which is what the company Apple did, then that's not descriptive. That is kind of distinctive, and you can apply for trademark registration. Trademark registration can last forever as long as you apply for renewal fees. And like patents, the process for trademark registration is quite straightforward if you want to do it through different countries, because you have the potential to, let's say, apply in Singapore and designate different countries. Let's say you want to do it in 7 countries, and you can designate 7 countries for ease of administrative application. I have a logo here. It's actually a music, some jingle. I don't know whether you guys can hear it. I played it. So what I'm trying to show here is that a trademark can also be a sound. And if you are doing a software and you created a distinctive jingle, okay, you can potentially apply for a trademark over a sound. Copyright, I think quite very simply, copyright in your space, what it actually may encompass would be your source code and your object code, okay? If let's say you are creating promotional materials, that can be protected by copyright. The good thing about copyright is that you don't have to register. So meaning, let's say if you have created a software code or you have created promotional materials, as long as you have put it down in writing, and by writing I don't mean physically writing it, it can be typed out, as long as it's reduced to some medium where it can be stored, then copyright immediately kicks in. Okay. The term of protection for copyright is 70 years after the death of author, so it can be quite long. It is free of charge because you don't have to register. It covers different types of works, like literary works, which are words, artistic works, which are your drawings and your logos, musical works. So let's say if you get somebody to compose some tune for you to be placed on social media advertisement or a jingle, as I mentioned, then you also can have copyright protection. So that was a very quick snapshot of the different types of intellectual property. Okay, these are the key ones that may potentially arise in your business.
Yep. Ren Jun, yeah, I think the questions are
this slide
coming
talks
in.
about these. Yes.
Yeah, the questions are coming in
Okay.
fast and furious. Yeah, so I think okay, so we have a question from Catherine. Given that you focus on the various IP on patent, copyright, and stuff like that, I think there are a few questions around that. So Catherine has asked, we touched briefly on patents. In Singapore, can a software be patented if it is an industrial application? Is it in an intangible form?
Okay. For software patents, I think the first thing to note is that it is possible to patent a software. When you create a software, then after that you want to sell it to people, that fulfills the requirement for industrial application. But your challenge typically for software patents are the first two elements. The first one being whether or not your software is new. The second one is whether or not your software possesses an inventive step. So when it comes to new, right? So let's say if you want to do a word processing document type of software. I mean, you have Microsoft Word out there and you've got different types of word processing kind of software. You create something which is quite similar, then clearly I don't think that will fulfill new because there are really so many versions of such software. Okay. But on the other hand, if in your space, I don't know, if you come up with some fantastic way to do an X-ray or to store X-ray images, okay, which will then allow doctors to conduct their daily visits to patients in a very streamlined fashion, and no other competitor out there has ever done it, then you may potentially fulfill the requirements of a patent, and your code and your software can be protected by patent. But even if you don't get patent protection because somebody else has something similar, there are other ways to protect your software, because as I mentioned, your codes can be protected by copyright. Okay, so you can immediately see from this example that for a particular thing, it can be potentially protected by different types of intellectual property rights. Okay, sometimes if you want to go for the full blast, which is the expensive one and gives you the most protection, that is the patent. Okay, but patents are quite expensive. But if you don't fulfill the requirements of a patent, potentially, you can still have copyright protection over it, right? Although the scope of the protection may not be so broad, you potentially can have trade secrets and confidential information, because I mentioned earlier on that there is trade secrets too as an intellectual property right, and trade secrets are free as long as you keep your things secret, your contracts are quite clear, you impose NDAs on your employees, then you still have some protection.
Yep. Okay. So another question that came out from Trademark is, two questions on Trademark. One, is it specific to industry? And two, what does unregistered means?
Okay. Yes, trademarks could be specific to industries. That's a very good question, because when I mentioned that when you apply for trademarks, it also depends on your goods and your services. And FYI, there are 45 different classes of goods and services. So let's say you want to register for computer software. That's class number 9. But you want to register for hotel services, that's another different class altogether. There are some companies, because their businesses, there is convergence, and their invention can apply to different types of industries. So they will apply for different types of classes of goods and services to ensure that the protection is broad enough. So yes, trademarks can be quite industry specific too. And to the question on unregistered trademarks, what it means is, okay, if let's say you have a brand, and looking at the screen now, Philips, if your company name is called Philips and you have never registered for trademark protection in this name Philips, do you have protection under law? That is the question. And sometimes you can have protection over an unregistered trademark, okay, or a brand. And how does that arise? If you have developed goodwill over your brand name over years, over a course of time, okay, then the law will accept that you have goodwill over your brand name, and you can take action against people who copy your brand name. then you ask me what's the difference, right? I mean, if that's the case, I might as well save money and don't register my trademark since the law gives me protection over unregistered trademarks. Then there you may be wrong, because it is quite difficult to go under the unregistered trademarks limb. You need to show that you are quite famous. You need to show that you have goodwill. So let's say if no one out there, I mean, Philips is a bad example. Everybody knows what Philips is. Okay, maybe my name, Ren Jun. If I use Ren Jun for some SME in MedTech, okay, I don't register for a trademark. 3 weeks later, some guy out there also sets up a MedTech company, sells medical software under the name Ren Jun. I have no action against him. Okay, it's going to be very tough for me to go after the person because I don't have a registered trademark and my name is my name, right? And I'm not famous yet. So when I'm not famous, I cannot invoke an unregistered trademark to go after people. So that is the beauty of registering. Yes, you do have to spend some money to register, but I think your returns on investment, sometimes may be worth it. You get more clear protection.
Thanks, Ren Jun. I know you have some very, very interesting case studies coming out,
Yep.
but I just want to maybe raise one question from one of the audience here before we move on
Sure.
to the rest of the presentation. So,
Sure.
so software and apps are protected under copyright. So that's one of the question. And in
Correct.
what case could you get patents on software?
Okay. Software, as I mentioned again earlier on, you can have copyright over the code. I tell you what's the difference. The copyright, your codes are so like even in binary form 0101100000, or your other types of computer codes or your JavaScript. Okay, you have protection over all these letters, for copyright. And if somebody comes up with a similar software, okay, but does not copy your code, but the outcome of the software and the function of the software is the same as yours, your copyright protection cannot stop him because your copyright protection only covers the codes. So if let's say he copy word for word or copy 90% of your code, you can go after him for copyright protection or copyright infringement. But if this guy is very smart, he comes up with some other codes, okay, but at the end of the day, the whole function of the software is the same. How do you protect yourself? You can only go after him if you have a patent, okay? But you need to spend money for patent rights. And as I mentioned, to get patent protection, you need to be a novel invention, okay? The threshold is quite higher because when the IP office look at how new your invention is, they compare your software against what has been disclosed, not just in Singapore, but all over the world. So they will probably do their Google searches. They will go and check, let's say in the United States, whether somebody has sought for a similar patent. So the threshold is quite high. But of course, if you get it, then your protection is very broad because going back to my example, if this guy who does not copy your source code, does not copy your object code, but the idea of the software that he creates, this competing software, is the same as your software, and the function of the software is exactly the same too. If you have a patent, you can stop him. If you don't have a patent, you cannot use copyright against him because the codes are different. The text of the code is different. I hope I addressed the question just now.
Yep. Yeah, they've responded to say that was very helpful insights. Yeah. Thanks,
Okay.
Ren Jun. We have some questions, but let's move on with your
Sure,
presentation
sure.
and your case study. Thank you.
Yeah. Thanks so much for the questions. I think I think these questions are very good and also very useful. So please feel free to raise them. I have prepared quite a bit of slides, but I can manage in terms of the time. I can try to cut down the content. I think having that interactive discussion probably also helps to engage you guys. So I just move on very quickly to this slide. It's called the significance of due diligence. And earlier on, when I talked about the different buckets of IP rights to give you guys a flavor of what types of IP rights exist. So due diligence meaning, you look at a company and you think about it, what potentially do I have? It's like checks, right? You want to check what you actually have to find the extent of IP that you have. So the whole idea of me trying to give you this basic foundational explanation on the different buckets is that, hey, maybe you realize that, hey, actually, I do not just have unregistered trademark. Maybe I have copyright in my code. I'm going to come up with a new invention. Maybe I can patent it. So you need to have the kind of thinking behind your business. Start thinking about intellectual property rights. Start thinking broad about what types of IP you may potentially have. And one way to go about doing it is you look at your business. What are the things that you are selling? What are the things that you are creating? How are you promoting it, for instance? Because the way that you promote your materials, okay, I mentioned earlier on, maybe you can have copyright. What are the things that are your industrial secrets, right? Then you may potentially have confidential information. So when you start thinking about it from a very foundational level, then you may realize that you can actually have a lot of IP assets within your company. Okay. These questions, I think earlier on in the course of my presentation, in the earlier slides, I've already more or less touched on it. And I think some of them have been raised during the Q&A that Gabriel kindly flagged to me. I just want to make a few comments here, okay? Maybe I'll take the last question, which is, when should your due diligence be conducted? There is no hard and fast rule. I actually recommend companies to do due diligence two ways. One, when you start out, okay, you need to start thinking about IP. I have seen a lot of clients who don't think about IP when they start out. And later on, I'll explain why it's not going to be good for you. They don't think about IP when they start out. They think about IP when they become big, when they are going to be acquired. No? So it's like a unicorn. And suddenly, I realize, hey, I'm not bad. Somebody's going to acquire me. So I work backwards and try to make sure that my intangible assets are all in shape. My value is properly recorded. Things don't really work that way. You need to get your basics right. You need to start thinking at the very outset, what potentially am I selling? What kind of IP assets do I have? How do I go about protecting it so that as I go along in my business, as my business grows, then my protection is secured, right? How do I restructure my assets, for instance? So these are things that you should think about. And not just you do it at the outset. Frequently thereafter, you conduct regular audits to make sure that everything is in shape. So if you start doing it at the outset, and then you conduct your regular audits, it's not going to take up too much of your time because it's like brushing your teeth. If you do it habitually, you don't see dentists. But then if you don't brush your teeth, then that's it. Your teeth decay. Sometimes you got to go for operation, go and put fake teeth inside. Then all these things going to cost you a lot of money and not very good for you also.
Yeah, hey, Ren Jun, thanks for this. I think with startups, they feel that applying for a patent seems like a very daunting process, and you just mentioned about cost, because it involves a lot of money, and
Correct.
then it's unclear if you would even be granted a patent. So how can one reduce this uncertainty and of course the cost as a small company to know whether it makes sense to spend all the time and money?
Okay. Look, there is no hard and fast rule on this. I actually suggest this. If let's say you have an idea which is very, very good, and if you are in this line, you will know whether your idea is very, very good, whether people know about it or whether there is a competing product out there. If your product is something which you also know in your heart of hearts that there is a competing product out there, then the chances are very likely you may not qualify for a patent. I don't suggest you going down that path. You may approach certain IP consultants or IP lawyers. Some are actually quite honest with you and they will tell you don't have a chance. Some may not be so forthcoming. They will say try lah. Okay. If you have a very good idea, my advice to you is that bet on the patent, because the patent will give you the maximum protection. If you are as a startup, yes, patents can be quite costly. There are funding kind of schemes that are available by the government, okay, especially when it comes to intellectual property. So later on, I will touch on some different types of funding that you can rely on. You may go to Enterprise Singapore, ask them to help you depending on whether you hit the criteria, whether you register a trademark or register a patent. Sometimes the government will defray the cost for you. Okay.
Thanks, Ren Jun. What about, I mean, this is a question that came out from the chat group as well. So, for example, if your medical device invention is still, pre-researched, that is no proof of effectiveness yet, what would you recommend as a suitable strategy to decide which country you want to extend your the patent protection?
Wow, very good question. Okay, sounds like the kind of questions that the MNCs will ask me, those hardcore IP lawyers. How to decide which country to file? That's a very good question because, as I mentioned, IP protection is territorial in nature. Registering in one country does not give you automatic protection in all the other countries. So to decide where to file, you need to think about where is your base. You need to let your commercial interests override. Where you want to be your HQ and do your first launch or your strongest market, that one definitely you got to take the box. You cannot run away from it. You need to protect it in that country. Where else to protect? You need to think about your business again, forward looking. Okay, maybe 5 years down the road, I want to expand in 5 countries in ASEAN, and I'm very, very sure that these are the countries I want to go into. Then you should also file in these countries. The same thing goes for trademarks also, because a lot of clients, even clients in deep pockets, especially during this pandemic situation, then they will say, hey, I budget cut, very expensive, How do I decide? Priority countries, you can have different phases, you can have different tiers of countries. So if you have budget problem, maybe your tier 1 countries are your super high priority countries, okay? Then tier 2, not so high priority. You do it in phases. Okay, then maybe that will help you to sort of split out the cost over a longer period of time.
Thank you, Ren Jun. Yeah, we'll carry on to the question maybe after a few slides.
Okay, sure. I'll move on very quickly now to the next phase. So the next phase is about pitfalls. In no particular order, I have set out some common pitfalls that companies face when it comes to protecting their intellectual property rights, especially for startups. When they start out their businesses, what are the so-called mistakes that they usually make? This slide, you will see ownership of IP rights. It's a very important topic. Who owns the IP rights? Because you may think, hey, this is my product. Okay, I'm selling the product. So whatever that happened before that, the creation of the software, who wrote the code, but it's my product, my company. I paid the guy to do it for me. So the IP is mine. Everything is mine. Not entirely true, because under law, if you have an employee, whatever your employee creates for you is presumed to be owned by you. But if you hire a consultant, because it's quite common, some SMEs or even MNCs out there, they try to get third-party consultants to do their projects. So they say, hey, I hire this guy, this software developer from, let's say, India or China, but he's not my employee. He's not getting CPF. I don't have an employment contract with him. So I just pay him on a project basis. He create the thing for me, but it's my product. The law presumes that if it's not your employee, this consultant is actually the owner. So how do you protect yourself? You have contracts. So if you have an employee, okay, whether it's an employee, whether it's a consultant, your contract must be clear. A lot of people, they omit the IP issue altogether from the contract. They just say it's a quotation, some PO order, okay, I pay you to create this, that's it. Contract not clear. Then how? If contract not clear, then you go to the default, which is a presumption, right, as I mentioned. So if it's a consultant in India or in China, or finish, the guy is going to be the owner of the IP. And how are you going to get him to transfer the IP to you? So imagine now you're a startup. 1 year later, you become the next Grab. And then after that, you say, oh, wow, my software is then valuable. But actually, this guy who developed my software at the very first instance 1 year ago, he's a consultant. And he's the owner of the IP. When he knows that you are big, and he knows that the software is valuable 1 year down the road, why would he agree to give you the IP back? He won't. He'll say it's mine. Right? You said, too bad for you. You didn't agree. My contract is very clear. You pay me $2,000 to create the software. That's it. Never say anything about IP. Okay, so these are things that you got to watch out for. Okay, exploitation of IP. So this exploitation means when you already have the IP, how you commercialize it. Okay, there are two main ways that you can commercialize it. And what I usually tell clients is rather than see intellectual property rights as a defensive mechanism, okay, where you do it just for protection and you just tick the box, or you do it so that if let's say people copy you next time, you can go and sue them. Don't see IP as that way only. Yes, IP can serve that defensive function, but I strongly suggest companies to look at intellectual property rights as something which is an asset that you can exploit. Okay, it's like your plant and your machinery. It's just that it is invisible. Okay, if you look at it as a commercial asset, okay, your entire thinking changes, because there are different ways where you can slice and dice your IP rights and exploit it for value, for money. So I'll give you an example, assignment. If let's say after doing your due diligence, right, earlier on I talk about due diligence, I talk about identifying different buckets of IP. One day you want to sell a business, for example, or you want to sell a part of your business. And this particular part of a business, after you do your due diligence, you listen to me earlier on, then you say, okay, yeah, makes sense. I do my due diligence. I cover, there are so many different buckets of IP. I want to sell. I want to assign my IP to this person. Yeah, good. So you can commercialize it. You can unlock the value. Another way to do it is license, right? And license is quite beautiful because there are so many types of licenses that are involved. I'll give you another example. A trademark franchise, right? Yakun, for instance. Yakun is licensed. That famous local coffee, Yakun, right? Or some other places, 7-Eleven. 7-Eleven also a license. So what do? They don't do anything. They don't sell the products. They sell they collect money from the use of the name. So if you become big or you are developing software and then you want to license the invention to people to also use in other countries, you can do it. But you can only do it if, let's say, you get your basics right. Are you protected in all these countries, right? If you're not protected, what is there to license? Nothing, right? Are you the owner? Because only owner can license. So you see how everything ties together if you have your basics right. You need to get your IP sorted out. You need to make sure that you actually have the IP in the first place. You need to make sure that if it's to be registered, it's already registered. You need to make sure that you are the owner. So once you get these two fundamentals correct, then you can talk about exploitation. You can license to people. You can even license in a way where, let's say, you want to have one licensee in India, you want to have another licensee in China, for example. Or you can even split it in a way where in Singapore, you can have two different licensees. One licensee to sell in brick and mortar shops and another licensee to sell online. So it's really up to you. But how you deal with it ultimately turns on you having it in the first place. So I cannot stress more than enough that you need to make sure that you actually have the IP assets. And by the statement, do you have the IP assets? The two things I mentioned, is it protected yet? Are you the owner? So these things you need to always bear in mind. Sole ownership and joint ownership, big problem if it's joint ownership. So if let's say you're a startup and then you have collaboration with other agencies or other companies, and some people, when they say they start, everybody are best friends, right? We have a very loose agreement, shake hands, 50-50, everything. We hope that we make everything that we own, maybe half, but nothing is said, nothing is written properly in the contract. You're going to have a big problem, okay? Or if you don't even talk about it at all, you say, I want to enter into this arrangement with another company, but I omit to talk about IP. Then who owns the IP? A or B? Or is it A and B? Then if subsequently next time the invention becomes very powerful, you want to exploit it and you want to license it out, you know that if let's say it's a joint kind of collaboration situation, potentially both people can own the IP. And if you do not have a contract to actually address how to exploit it, A cannot license out without B's consent. And similarly, B cannot sell the IP without A's consent. And then what if 3 years on the road, you all break up already? Right? I mean, at the very start, the relationship can be very rosy, but you never know what's going to happen 2 years down the road. So it's very, very important that when you enter into any form of collaboration, you need to very clearly stipulate all your rights and your obligations when it comes to intellectual property with the other party. Okay, another risk, disclosure. This one, very famous one, the risk. If you talk about it outside, your trade secrets are finished. If you disclose it on social media, your trade secrets also finish. For patents, remember just now I talked about the requirement for it to be new. If let's say you have a R&D project, and then you don't protect this prototype very properly, people talk about it, you don't lock it up, somehow other people get to know about it, that's it. Your novelty also gone. So you cannot apply for a patent if your novelty is gone. So it's very, very important that you, if it's something which you want to protect eventually, but you're still working on it, make sure that you limit the number of people that know about it. If people are working with you, make sure that you have agreements, okay, with them, to impose confidentiality obligations on them. It's like a non-disclosure agreement. So that if one day these people, they go on a frolic, or they leave a company, or they hate you, they go outside and then they talk about this invention, you can still protect your invention because the law allows you to preserve confidentiality and also novelty for patents. If you have an agreement with somebody to say that it is secret and the person actually breached the agreement. So it's like that piece of paper, the NDA, is going to be your safeguard. It's like your security blanket. Okay, enough of me talking about the law. I prepared a case study, quite a simple one. SME is a medical device startup, and SME's employees have developed new tech for a medical device. So contracts are bare bones. SME's employees post about the new tech on LinkedIn in detail. Then now SME wants to file for a patent. What issues will SME face? Quite simple, right? Once disclosed to public, invention is no longer novel. Okay, so your first criteria for patent registration is not met. That's it. You lose protection or the ability to protect your IP anymore. SME decides to partner with a consultant to do a joint development of a mobile application. And as negotiations between SME and the consultant was conducted informally, no contract was concluded between them. SME now wants to license the application to a big MNC when the project is completed and plans to do so on its own. Can SME do so? Remember, just now I talked about the joint ownership problem, right? If the contract is not clear and you enter into a collaboration, then it's very vague. No one knows what is going on. So you cannot license without the other party's consent. Because if you license without the other party's consent, the other party can come after you for infringement or say that you breached the arrangement. We're supposed to be joint owners. You never say that you own everything fully. What? So why you want to go outside and license out this IP right that we jointly own? So these are the risks, okay? And I'll just pause here to talk a bit more about the kind of collaboration agreement that you can potentially have. The beauty about agreements is that the courts in Singapore, they will respect parties' intention. So it is good for you in the sense that if you start thinking about this issue and you are very serious about trying to think about what's going to happen, the different scenarios, you want to think about, okay, how to strengthen your rights and obligations, you can do so. As long as your contract properly spells out all these scenarios, as long as your contract very clearly states out what parties own, how parties are supposed to deal with the IP rights, the courts are going to respect it. So what I'm trying to say here is that contracts are quite easy and very powerful. So because the courts in Singapore, they respect freedom to contract. So as long as you think about it, as long as you write it down, of course the other party must agree, then you have it, 4 corners of a contract. Everything is stipulated there already. So the more you think about things, better for you, because you think of all these scenarios. What's the mistake the companies make? They don't think about it. They don't think about it, so therefore the contracts are very vague. They don't think about it, so therefore they don't address the different permutations and the different scenarios. Okay. I'm not sure whether there are any other questions that are appearing. I'm happy to address the questions in the second part now before I move on to the third part.
Okay, let's see. I think there's one question on search databases. You know, what are the best search databases to confirm that there's no other software that is similar to your healthcare software before you apply for a patent, say in EU or US?
Okay, good question. EU and US. Let me tell you how. Let's say if you want to apply for a software patent in Singapore, and then how would the Intellectual Property Office of Singapore look at your application? Okay, from my experience, the first thing they will look to is the US Patent Office and also the EU Patent Office. I mean, if you are sophisticated enough, I mean, these kind of things, I suggest that you get some expert to help you. But if you feel that you can do it yourself, okay, there are some publicly available searches on, let's say, the US Patent Office website or the EU Patent Office website. But you need to know how to use them. So when you search, then after that you search for the invention, there are different search terms that you can use. Google is another source that sometimes they turn to. Publications also. But I need to caution you guys here also, because if let's say whether it's a patent or a trademark, sometimes the intellectual property officers, when they do their job, then they realize that maybe there's nothing out there. There will be a period of time before you get registration, and also subsequently after you get registration, where parties, third parties out there in the world, okay, they can challenge you. So I give you an example. I want to apply for the trademark Apple for a software device. Assuming that this trademark examiner working in the Intellectual Property Office of Singapore maybe work from home too much, never sleep, so fail to pick up Apple's trademark, right? And then say, "Wow, Ren Jun, your Apple, no one out there apply for Apple," give you a tick. Then after that, there will be a period of time before I get registered. The real Apple out there, when it comes to know about my application that is still pending, they can challenge me, they can oppose me, or subsequently after I get my registration, then Apple finds out. Apple can apply to cancel my registered right. Okay, so in a nutshell, there are all these mechanisms that can kill your IP registration or kill your pending IP application. So what does it mean? It means that you need to make sure that whatever you are seeking to protect is something that is defensible, right? Because if it's a very weak right, chances are A, the IP office will refuse your application, or B, third parties out there can challenge your application or cancel your registration. What will it mean for your business? It means that you have no IP protection. It means that you have wasted money trying to protect something that should not have been obtained in the first place.
Thank you, Ren Jun. Yeah, Ren Jun, I think we have maybe about 7-8 minutes left.
Okay.
So I think I'll leave the rest of the time to you.
Okay, sure. Okay. How to ensure a strong IP portfolio? I want to talk about structure, okay, of ownership. I give you an example for Grab. When Grab was very, very young, okay, there was only one company, right? And now, of course, it becomes such a huge company and there are different subsidiaries. And every different subsidiaries are doing different things. From day one, if let's say you are a startup, or even right now if you're an MNC, because it cuts both ways too, you need to think about the structure of your IP ownership. which company within your group, or eventually when you become bigger, are you intending to hold your IP within a single company? You want to have a separate company, for instance, or if now you are MNC, you have different countries which are within your permit, okay, and you want to look at it, where do I register? Who is going to hold the IP rights? Is it the Singapore company that's going to hold it? Is it the Swiss company that's going to own it? Is it a Malaysia entity, for instance? This is a very important exercise that you should think about, because ultimately, if you have IP that is owned all over the shop, and then you think about it, how are you going to license? You may be confused, as to who has the IP. Maybe you license out to another third party, but actually this Malaysia entity that that's under your group may not have the IP. So structure is important. And Singapore, I give you Singapore as an example, because Singapore, the government always wants Singapore to be an IP hub. So they wanted Singapore, if you are doing business, you try to base all your intellectual property within Singapore. And what are the benefits that you can obtain? Tax incentives, financial assistance from government. So I've done projects for companies, whether they have regional operations, ASEAN, Asia Pacific, or across the world. They think about this issue of ownership and structure. Then they say, okay, I trust in Singapore. I'll create a Singapore holding company. I will transfer all my intellectual property assets. It could be a US patent. It could be a Switzerland trademark. It could be, let's say, some China confidential information. I'm going to migrate everything into Singapore so that everything will be held under the Singapore holding company. And then subsequently, the Singapore holding company will then exploit the IP either internally, meaning within the group to its own subsidiaries, or externally to third parties. And within the group, mind you, when let's say the Singapore holding company needs to enter into some intra-group, okay, within the group arrangement with subsidiaries across the world, what are you generating? You are generating intra-group license fees, intra-group royalties, income that flows back to the Singapore company. And what is your end game? Your end game is that when you create income back to this Singapore IP holding company, you avail yourself to these two things: tax incentives and financial assistance from government. Okay. I mean, there are a lot of details concerning this subject. There are tax elements involved too, but I just wanted to raise this as an important consideration for companies. Ownership and proprietorship, most of it I touched on earlier on already. I'll quickly speed through in the interest of time. NDAs and confidentiality agreements, yes, it's very important because you need to enter into these agreements with either your employees, your consultants, or your third parties to ensure that your IP assets do not lose the nature of confidence or novelty when it comes to patents. Regulatory compliance, okay. I know today's topic is really on IP, but I want to put regulatory issues out also very quickly. I'll speak about it for 30 seconds. A lot of people come to me, they say, they say IP rights are like your crown jewels. Yes, IP rights can give you monopoly. Yes, okay. But in your space, I feel that there is another crown jewel or another way where you can create a monopoly, and that is your product license. Okay, you need to make sure that your product licenses are properly applied for and owned by yourself. If you're using a third party, well, you better make sure that you have proper contracts to get them to transfer your product license back to you if the relationship is terminated. I have done a lot of disputes with, let's say, pharmaceutical companies or medical device companies in Indonesia, where they use distributors to own the license. Then the relationship broke up. The distributor refused to transfer back the license to the product owner. So what does it mean? The product owners cannot do business without these licenses, right? It's like they are held to ransom. So this is one issue that you guys have got to consider and put at the back of your heads. International outlook, I touched on it earlier on, the nature of IP being territorial. So you need to think about it also from an international perspective. Finally, some case studies here. So we established that SME will not be able to file for the patent earlier on, and SME has other projects that have yet to be patented and that does not want to repeat the previous incident. So right now they have a lot of people working from home, and as SME does not have enough portable laptops, a few members of the team are using their own laptops for work. What steps can SME take to ensure important information is kept secure and confidential? I mentioned earlier on, you need to have your agreements with your employees and your third parties. Conduct proper training for your employees. Cyber attack also very important, okay? You guys must have read about the Sing Health case, right? The cyber attack can cripple your systems. So it's important to also keep cyber security at the back of your heads. SME cannot unilaterally license the application to the MNC. SME decides to prepare a contract that sets out the terms of joint ownership. What should be included in the contract to protect SME's rights? So on this slide, earlier on I talked about this four corners contract. You can say what you want, subject to parties all agreeing. So later on, I think Gabriel will send you guys the slides. But this slide really sets out the key terms that you should have when you talk about collaboration. MNC wants to acquire SME and conduct due diligence on SME's business. But of course, SME's R&D has developed a variety of cutting-edge proprietary detection methods. So the concern is now, okay, MNC wants to come into my house and wants to do due diligence on me by got all these proprietary information. So what precautions should SME take during the due diligence exercise? Okay, very simple. Contract again, get them to sign an NDA. Okay, I've come to the end of my presentation.
Yeah, thank you, Ren Jun. Yeah, I think that this is really an important topic, and we might want to do something towards the at the end of the year. So especially when we can have a face-to-face meetings. But clearly, IP is really important because signs point to Asia Pacific becoming a MedTech innovation hotspot. And I think the conditions are right, in countries like Australia, Japan, Singapore, Taiwan, South Korea, and China for innovation to take off. And I'll just cite one example. Hillrom, for example, they opened their Asia Pacific Innovation Center in Singapore in 2008. And today it has more than 100 R&D centers focusing on R&D projects for global applications of various Hillrom products. And I'm sure IP would be central to the R&D folks in companies that operates R&D centers. Given the healthcare sector's strong reliance on high quality research and valuable ideas, protection of commercial advantage for innovation is extremely vital. So I just want to thank Ren Jun again. I just want to highlight a few key takeaways. First of all, I think IP create value in MedTech, helping companies to identify the true blue opportunities. Secondly, IP also covers the whole product cycle as what Ren Jun mentioned, from the initial idea through to the final commercial end use of any medical products. And another key takeaway, especially considering that many of our startups are really at an early stage side, to really start early, especially for early stage companies, because patents are often the only way for investors to place value on a company's technology and judge the potential success before sales. So these are some of my key takeaways. I just want to thank all of you for joining Ren Jun and myself at today's webinar. And we will send the slides across those who attended the webinar today. And feel free to let us know if you have any questions for Ren Jun or myself. Meanwhile, thank you. Keep well and stay safe. Thank you, Ren Jun.
Hey, thank you. Bye-bye.
Yeah, bye-bye.